In respectful presence of our brothers and sisters across boundaries and faiths, let us all join in prayer and worship and gratitude and for guidance. Almighty and eternal God, we thank you for the gift of life and all its joys. We thank you for today, for all its challenges, in all its splendor. We thank you for the gift of one another. O God of infinite mercy and wisdom, only in unity with your will can all our toils have true meaning. Transform us into willing and able stewards of this world and its future. Bring us together to work with understanding and compassion. As we toil and grow weary, we pray for renewed strength and resolve. As we experience pain and sorrow, let us be reminded of untold good beyond. As we see pain and suffering, let us be instruments of your peace and extensions of your loving and healing hands. As we gather here today, bless us all that our collective knowledge be tempered and guided by your wisdom. Grant us clarity of vision to see the common good amidst all distractions. Endow us with humility and purity of heart to transcend all differences and reservations. When we leave this gathering, let us be the change we seek. As we endeavor to practice what we learn, let us be the good we want to see in others. As we work for our learners and their future, let it be that your will be done. In solemn silence, let us conclude with our own personal prayer.
Mga kababayan, ang pambansang awit ng Pilipinas.
Kayang magiliw, telos ng sinakanan, alam ng puso, sa titik mo'y buhay. Upang hinirang, tuyag ka ng magiting, sa manlulupin, di ka pasisigil, sa nagatak tutok sa simoy at sa langit mong pagaw, ay hinatang tula, kawin sa paglayang minamahal. Ang isang ng matawad mo'y tagumpay na naghihingi, ang bituin at araw niya kailan pa may di magdidinig. Luman ang araw ng walhating pagsinta, mo'y langit sa piling mo. Ang hinigaya ng pagkay mga api, ang mamatay ng dahil sa'yo.
Over on Facebook Live, I'm Regina and I am your host for PALS Free Week, the frequently asked topics on the bar subjects. Welcome to our dear deans, speaker, professors, and bar takers tuning into our stream. This is the second lecture from this series and we're very excited as we help our barristers prepare for their exams. For today, we will answer the FAQs on political law to accompany what you already know. The PALS Free Week frequently asked topics on the bar subjects lecture series is brought to you by the Philippine Association of Law Schools in collaboration with Rex Bookstore and Rex Educacion. To know more about our event partners, let's all watch this video.
Ako si Romel, proud to...
Isa pa lang ng book development, kasama na ako. Working with the authors, so sa journey ng libro hanggang sa magamit na ito ng mga learners. Para makatulong to make them whole and responsible Filipinos. It's a good feeling.
Maaaring sa iba ay tagasakay ka lang naman ng papel sa makina. Ngunit, ang kada papel na iyon ay siyang bumubuo ng isang libro na
Puyat. Ngayon buo na, ngayon isa ng libro. I am full of hope na ang bawat makabasa nito, matuto, makinabang at makibahagi.
Teacher ang nanay ko. Proud akong gumising sa bawat araw na alam kong may ginagawa ko na makakatulong sa kanya sa araw-araw niyang pagtatrabaho.
Proud ako maging print production group manager.
So proud ako kasi alam kong may isang tao rin ako matulungan sa pagsusulat nito.
Proud ako kasi bawat customer na nakakaharap po namin dito sa branch, laging may kwento. Ang anak ko, naku, ayun, pumasa na sa kanyang exam. Salamat sa inyong libro. O di kaya may lalapit na, buti na lang may kopya kami ng ganitong title. Hulog kami ng langit. Ang makita ng ganitong mga ngiti sa mga customers sa tuwing nakakuha sila ng kopya ng title ng libro, nakakagaan din ng loob. Kasi
Thank you so much, Rex Bookstore and Rex Educampion, for collaborating with us on this event. Today's program aims to determine the most frequently asked questions for political law. These FAQs will be determined and answered by a distinguished guest this afternoon, and they have prepared a presentation to help the bar takers as they take the exam of their life. To introduce our speaker, Damina T. Rances is the Dean of the Ateneo de Naga University College of Law. She is a dual qualified lawyer in the Philippines and in the state of New York. She obtained her Juris Doctor with honors from the Ateneo de Manila University and her Master of Laws with graduate certificate in business law from the University of Southern California. She is also a partner at the Aguilar Rances Law Offices and the trustee of the Climate Action and Human Rights Institute. She was a former head executive assistant of the Department of the Interior and Local Government, former commissioner of the Housing and Land Use Regulatory Board, former director of the Social Housing Finance Corporation, and former consultant at the Commission on Human Rights. She teaches political, commercial, and remedial law subjects in various law schools in the country and is currently the treasurer of the Philippine Association of Law Schools. Without further ado, let's all welcome this afternoon's lecturer, Dean Damina T. Rances.
Hello, everyone. It's truly an honor and a privilege to be a part of your bar journey. I know that many of you are now feeling the nerves, so let me keep you company and let's just chill for 3 hours of reviewing the frequently asked topics in political and international law. As time is gold, let's begin. We start with the Declaration of Principles and State Policies, the provisions under which have been asked 13 times in the last 15 years. We all know that the general rule is that the provisions of the Constitution are self-executing and do not need further legislation for the enforcement. But of course, there are exceptions. Now, why is it important to determine if a constitutional provision is self-executing or not? Well, because Manila Prince versus GSIS tells us that only the self-executing provisions embody judicially enforceable rights and therefore can give rise to a cause of action in court. Meaning, you can't claim a violation of the Constitution if your ground is based on a non-self-executing provision. And this is precisely what happened in Council of Teachers and Staff of Colleges and Universities versus Secretary of Education. This case, penned by your bar chair, is about the constitutionality of the K-12 law. The petitioners allege that the law violates Section 13 of Article 2 on fostering patriotism and nationalism on the youth, Section 17 on giving priority to education, Section 18 on the protection of the rights of workers and promotion of their welfare, and certain provisions of Article 14 on education, language, and culture. So Justice Caguioa said that there can only be a violation of these constitutional provisions if these provisions are self-executing. Now, how do we determine if a constitutional provision is self-executing? We go back to Manila Prince Hotel, which said that a constitutional provision is self-executing if the nature and extent of the right conferred and the liability imposed are fixed by the Constitution itself. so that they can be determined by an examination and construction of its terms. And there is no language indicating that the subject is referred to the legislature for action. Unfortunately, the provisions cited by the petitioners, particularly those in Article 2, are all non-self-executing. It has long been held that by its very title, Article 2 of the Constitution is a declaration of principles and state policies. These principles are not intended to be self-executing, ready for enforcement through courts. What then are the value of these provisions in our Constitution? Wala, trip lang, mema, para maganda, ganun, char. No, of course they are used by the judiciary as aid or as guides in the exercise of its power of judicial review and by the legislature in its enactment of laws. But take note that as usual, there are exceptions. Section 15 of Article 2 on the right to health was declared as self-executory in Imbong versus Ochoa, the RH law case. Also, Section 16 on the right to a balanced and healthful ecology in the landmark case of Oposa versus Pactoran. And finally, Section 18 on the duty of full public disclosure of transactions with public interest in the controversial MOA AD case of Province of Cotabato versus the Government of the Republic of the Philippines. Now let's go to national territory, asked 4 times in the bar. To memorize this, it would be best to break this long provision into 3 parts. Just remember, Philippine Archipelago, all other territories, and internal water. So the national territory comprises the Philippine Archipelago with all the islands and waters embraced therein. What is an archipelago? It is a body of water studded with islands or a group of islands, interconnecting waters and other natural features which are closely interrelated, forming one intrinsic geographical, economic, and political entity. Second, all other territories over which the Philippines has sovereignty or jurisdiction. This includes those which we claim by historic right or legal titles such as Sabah, the Kalayaan Island Group, and all other future acquisitions that we might get through any of the international modes of acquiring territory, if may capacity tayo. And it's consisting of its terrestrial, fluvial, and aerial domains, including its territorial sea, the seabed, the subsoil, the insular shelves, and other submarine areas. And finally, the waters around, between, and connecting the islands of the archipelago, regardless of their breadth and dimension, form part of the internal waters of the Philippines. This last sentence actually pertains to the archipelagic principle, which states that an archipelago, through the use of the straight baseline method of delineating the territorial sea from the internal waters, shall be regarded as a single unit, so that the waters around, between, and connecting the islands of the archipelago, irrespective of their breadth and dimension, form part of the internal waters of the state and are subject to its exclusive sovereignty. Now to the maritime zones, asked 10 times already. This is not included in the illustration, but the waters on the landward side of the baseline of the territorial sea form part of the internal waters of the state. But for us, as an archipelagic state, and as what we have reserved when we signed the UNCLOS, and as stated in our Constitution, the waters around, between, and connecting the islands of the Philippine archipelago, irrespective of their breadth and dimension, form part of our internal waters. Ordinarily, there is no right of innocent passage over internal waters. But because our internal waters are technically archipelagic waters, then it may be subject to the customary right of innocent passage, which our state can regulate by legislating the designation of archipelagic lanes as held in Magallona versus Ermita. As for your territorial sea, Oh, don't mind the 3 nautical mile in the illustration. The 3 nautical mile was the old delineation of the territorial sea that has already been abandoned by the passage of UNCLOS. Now, every state has the right to establish the breadth of its territorial sea up to a limit not exceeding 12 nautical miles measured from baselines. Sovereignty over these waters, including the airspace above it and the seabed under it, is the same extent as its sovereignty over land. Here, there is a right of innocent passage. Then the contiguous zone. It is that area of water not exceeding 24 nautical miles from the baseline. It thus extends 12 nautical miles from the edge of the territorial sea. Although not part of the territory, the coastal state may exercise control necessary to prevent infringement of its customs, fiscal, immigration, or sanitary laws here in the contiguous zone. Next, we have the exclusive economic zone, which shall not extend 200 nautical miles from the baselines. In the EEZ, the coastal state has sovereign rights for the purpose of exploring and exploiting, conserving and managing the natural resources, whether living or non-living, of the waters super adjacent to the seabed and its subsoil, and other activities for the economic exploitation and exploration of the zone, such as the production of energy from the water, currents, and winds. It also has jurisdiction with regard to the establishment and use of artificial islands, installations and structures, maritime scientific research, the protection and preservation of the marine environment, and other rights granted by the UNCLOS. So, to be clear, the coastal state has no sovereignty over the EEZ. What the coastal state only has are sovereign rights, jurisdictional rights, and other rights under the UNCLOS. Now let's go down to the continental shelf, also known as the archipelagic or insular shelf, which refers to the seabed and subsoil of areas adjacent to islands, and also the seabed and subsoil of the submarine areas adjacent to the coastal state, but outside the territorial sea to a depth of 200 meters. Now the extended continental shelf. It is that part of the continental shelf that lies beyond the 200 nautical miles from the coastal baseline up to a maximum of 350 nautical miles. In both the continental shelf and the extended continental shelf, the coastal state exercises sovereign rights for the purpose of exploring it and exploiting its natural resources. Finally, we have the high seas. The high seas are beyond the jurisdiction and sovereign rights of states. It is treated as res communis, or for the common heritage of mankind, or res nullius, not belonging to anyone, and thus they are not part of the territory of any particular state. What are the allowable acts in the high seas, also called the freedom of the high seas? First, we have freedom of navigation, freedom of overflight, freedom of scientific research, freedom to construct artificial islands and structures, freedom of fishing, and freedom to lay submarine cables and pipelines. Let's now jump to separation of powers, asked 5 times in the bar. The principle of separation of powers ordains that each of the 3 great government branches has exclusive cognizance of and is supreme in concerns falling within its own constitutionally allocated sphere. When is there a violation of the doctrine of separation of powers? Well, when one branch of government unduly encroaches on the domain of another, it may be violated in 2 ways. First, when one branch interferes impermissibly with the other's performance of its constitutionally assigned function, and second, when one branch assumes a function that is entrusted to another. Example, in Reconanan, Congress passed the Bar Flunkers Act to admit to the legal profession, under certain conditions, those who did not pass the bar in consideration of the hardships experienced during World War II. The court ruled that this was an encroachment on the power of the court to determine who may be admitted to the practice of law. Oh, I think that's not a very good example. Another example is Estipona versus Lobrigo, where the court struck down the provision of law prohibiting plea bargaining in drug cases on the ground that it encroaches on the power of the court to promulgate rules or on pleading, practice, and procedure. Then you also have Corpus versus People, where in an estafa case, several justices of the Supreme Court were of the opinion that it is not fair to apply the range of penalties in the RPC, which was based on the value of money in 1932, to crimes committed at the present. But the majority of the justices opposed this view because altering what is in the law would amount to judicial legislation, which is, of course, a violation of the principle of separation of powers. Now, the concept of checks and balances refers to the system operating between and among the three branches of government, the net effect of which is that on certain important matters, no one department is able to act without the cooperation and/or oversight of at least one of the other departments. Some constitutionalists also refer to this as the blending of powers. What are some of the checks and balances provided in the Constitution? We have several examples here. First, the president prepares the budget and the Congress enacts an appropriation. The president prepares the budget and the Congress enacts an appropriation bill pursuant to that budget, but the Congress may not increase the appropriation recommended by the president for the operation of the government as specified in the budget. 2. The president must obtain the concurrence of Congress to complete certain acts. For amnesty, the president needs the concurrence of a majority of all the members of Congress. For the effectivity of a treaty or an international agreement, the president needs the concurrence of at least 2/3 of all the members of the Senate. Third, enrolled bill needs the final approval from the president to become law, and if vetoed, it may still be overturned by Congress. Speaking of enrolled bill, isingit ko na rin, chair case alert. In Council of Teachers versus Secretary of Education, the same case we mentioned earlier on the K-12 law, one of the arguments of the petitioners for its unconstitutionality was that the enrolled bill, which the president signed into law, varies significantly from the reconciled version of the bill as approved by Congress and reported in the Senate Journal, and that the court, pursuant to its ruling in Astorga versus Villegas, should look into the entries in the journal to determine whether the K-12 law was actually duly enacted. Now, as you may recall, under the enrolled bill doctrine, the signing of the bill by the Speaker of the House and the Senate President, plus the certification of the secretaries of both houses of Congress that it was passed, is conclusive, not only as to its provisions, but also as to its due enactment. The rationale behind the enrolled bill doctrine rests on the consideration that the respect due to co-equal and independent departments requires the judiciary to act upon that assurance and to accept that Congress passed all bills authenticated in the manner stated. Here, the court ruled that petitioners' reliance on Astorga is quite misplaced. They overlooked that in Astorga, the Senate President himself, who authenticated the bill, admitted the mistake and withdrew his signature, so that in effect, there was no longer an enrolled bill to consider. Without such attestation, and consequently, there being no enrolled bill to speak of, the court was constrained in Astorga to consult the entries in the journal to determine whether the text of the bill signed by the chief executive was the same text passed by both houses of Congress. Now, in stark contrast to Astorga, this K-12 case presents no exceptional circumstance to justify the departure from the salutary rule of the enrolled bill doctrine. Thus, there is no reason to look into the entries of the journal, as there is no doubt as to the formality and validity of the enactment of the K-12 law. Let's go to number 4. The Supreme Court can declare unconstitutional the acts of the executive and the legislative through its power of judicial review. 5. Certain presidential appointments need the confirmation of the Congress through the Commission on Appointments. 6. Congress wield the power of impeachment over the President, the Vice President, the members of the Supreme Court, the members of the Constitutional Commissions, and the Ombudsman. And finally, 7, the President may grant reprieves, commutations, pardons, and remit fines and forfeitures after conviction by final judgment of the court. Let's now go to state immunity, which has already been asked 13 times. Under Article 16, Section 3 of the 1987 Constitution, the state may not be sued without its consent. Now, question. Without this constitutional provision, will the Philippine government still have immunity? Yes, sis, because state immunity is actually a generally accepted principle of international law. And by virtue of the doctrine of incorporation under Article 2, Section 2, we adopt the generally accepted principles of international law as part of the law of the land. Anyway, the doctrine of state immunity is based on the principle of equality of states, par in parem non habet imperium, according to which a state may not impose its authority or extend its jurisdiction to another state without the consent of the latter through a waiver of immunity. So, domestic courts must decline to hear cases against foreign sovereigns because of this principle. However, absolute sovereign immunity, where a state cannot be sued in a foreign court regardless of the cause of action, has now evolved into a restrictive application of sovereign immunity, where a state is only immune from suits involving government actions or cure imperi, but not from those arising from commercial or non-governmental activity, or cure gestionis. So when you encounter questions on state immunity, the first thing that you have to determine is whether the state is engaged in governmental or proprietary functions. State immunity does not just apply to suits against foreign states insofar as they are sought to be sued in the courts of another state, but it also applies to suits between the state and its own subjects. In such an instance, the rationale behind it is, of course, not anymore based on the principle of equality of states, but rather the principle that there can be no legal right against the authority which makes the law on which the right depends. This principle also seeks to prevent the loss of governmental efficiency as a result of the time and energy that it would require to defend itself against lawsuits. It is also known as the royal prerogative of dishonesty because it grants the state the prerogative to defeat any legitimate claim against it by simply invoking its non-suability. The doctrine of state immunity also applies to complaints filed against officials of the state for acts performed by them in the discharge of their duties within the scope of their authority. Does this also extend to government agencies? Well, it depends on whether the agency is incorporated or unincorporated. If the agency is incorporated, the test of its suability is found in its charter. It is suable if its charter says so, and this is true regardless of the functions that it is performing. However, if the charter is silent, then you have to inquire into its function based on the purpose for which it was created. Now, if the government agency is unincorporated, meaning it has no separate judicial personality, as a general rule, then suits filed against it are necessarily actions against the state of which it is a part. How do we then determine if the suit is really against the state? The test is whether the satisfaction of the judgment against the public officer or agency impeded will require an affirmative act from the state, such as the appropriation of the needed money or amount to satisfy the judgment. So, how may a state give its consent to be sued? It can be by express consent through a general law like Act number 3083, where the Philippine government consents and submits to be sued upon any money claim involving liability arising from contract, express or implied, which could serve as basis of civil action between private properties. Another example would be the Civil Code provision, which states that LGUs are liable for injuries or death caused by defective condition of roads or public works under their control. The express consent may also be made through a special law. An example of this is PD 1620, which provides that the International Rice Research Institute shall enjoy immunity from any penal, civil, and administrative proceedings. Then we have implied consent. This occurs when the state enters into a business contract, unless such is merely incidental to its governmental functions. Or when the state commences litigation, it becomes vulnerable to a counterclaim unless the suit is commenced to resist the claim. And finally, the application of immunity would serve as an instrument of perpetuating injustice to a citizen. Like when a property is taken without just compensation, the defense of immunity from suit cannot be set up in an action for payment by the owner of the property. So we have a chair case alert, PTRI versus Court of Appeals. In this case, the Philippine Textile Research Institute is an unincorporated government agency under the DOST. It entered into a contract for the rehabilitation of its electrical facilities in its building. The contractor then filed suit against PTRI for allegedly terminating the contract in bad faith. PTRI said that as an unincorporated government agency, it is immune from suit. The court, however, found that PTRI expressly consented to be sued via the general law, where the Philippine government's consents and submits to be sued upon any money claim involving liability arising from contract. As PTRI is being sued upon a claim involving liability arising from a contract, then the general law on the waiver of immunity from suit finds application. Furthermore, under the subject contract itself, which actually contemplated a situation wherein legal action may arise from the execution of the agreement and incorporating provisions on the procedures to be undertaken in settling disputes, PTRI, when it signed the contract, also manifested unequivocally its consent to be subjected to suit with respect to disputes arising from the subject contract. Finally, the court ruled that the subject contract was clearly not executed in the exercise of PTRI's governmental function of aiding the textile industry, as we've said, the subject contract dealt solely with the rehabilitation works of the electrical facilities of PTRI's buildings. Hence, PTRI consented to be sued. But before we leave this topic, you must remember that consent to be sued does not include consent to the execution of judgment against it. Such execution will require another waiver because the power of the court ends when judgment is rendered. Since government funds and properties may not be seized under writs of execution or garnishment, unless such disbursements are actually covered by appropriation, then in order to enforce monetary decisions against the government, you would still need to file a claim with the Commission on Audit. Let's now go to delegation of powers. Legislative power is the authority to make laws and to alter and repeal them. Section 1 of Article 6 states that the legislative power shall be vested in the Congress of the Philippines. As vested by the Constitution in Congress, legislative power is therefore a derivative and delegated power. And the general rule is that delegata potestas non potest delegari, or that what has been delegated cannot be further delegated. This is based on the ethical principle that such delegated power constitutes not only a right, but a duty to be performed by the delegate through the instrumentality of his own judgment and not through the intervening mind of another. But in spite of the principle of non-delegability of legislative power, it is common knowledge that numerous statutes have been passed creating administrative agencies and authorizing them to exercise vast regulatory powers. The rules and regulations they issue have the force of law. This phenomenon is said to be justified by two different theories. The first theory is that a non-legislative body may be authorized to fill up the details of a statute. This is known as subordinate legislation. The other theory is that Congress may pass contingent legislation, that is, legislation which leaves to another body the business of ascertaining the facts necessary to bring the law into actual operation. But take note that under both theories, the function performed by the administrative agency is not lawmaking, but rather law execution. And in order to ensure that the power delegated by the legislature is not lawmaking, the statute making the delegation must pass two tests. First, the completeness test, and second, the sufficient standard test. The completeness test states that the law must be complete in all its terms and conditions when it leaves the legislature, such that when it reaches the delegate, the only thing that the delegate will have to do is to enforce it. The policy to be executed, carried out, or implemented by the delegate must be set forth in that statute. Now, the sufficient standard test, on the other hand, mandates adequate guidelines or limitation in the law to determine the boundaries of the delegate's authority and prevent the delegate from running riot. To be sufficient, the standard must specify the limits of the delegate's authority, announce the legislative policy, and identify the conditions under which it is to be implemented. It must, however, be remembered that as stated in Edu versus Ericta, a very old case, the standard may be either express or implied from the policy and purpose of the act considered as a whole, provided that the requirements of completeness and sufficiency of standards are satisfied. The regulations passed by an administrative body pursuant to the delegation made by the statute are just as binding as if the regulation had been written in the original statute itself. If, however, these requirements are not satisfied, the regulation will not be allowed to affect private rights. And again, this was an issue in our favorite chair case of Council of Teachers versus Secretary of Education. Here, the petitioners allege that the K-12 law was incomplete because it allegedly failed to provide sufficient standards by which the DepEd, the CHED, and the TESDA might be guided in addressing the possible impact of the implementation of the K-12 law on labor. And what did the court say? The court disagreed and found that the K-12 law adequately provides the legislative policy that it seeks to implement. Particularly in its declaration of policy, and all the provisions scattered throughout the K-12 law, there are the standards to guide the DepEd, the CHED, and the TESDA in carrying out the provisions of the law. And so, read in its entirety, it is complete in all essential terms and conditions and contains sufficient parameters on the power delegated to the DepEd, CHED, and TESDA. The fact that the K-12 law did not have any provision on labor does not make that law incomplete, since the purpose of permissible delegation to administrative agencies is for the latter to implement the broad policies laid down in the statute by filling in the details, which the Congress may not have the opportunity or even the competence to provide. And with the proliferation of specialized agencies and their attendant peculiar problems, the legislature has found it necessary to entrust to administrative agencies who are supposed to be experts in their particular fields the authority to provide direct and efficacious solutions to these problems. This is effected by the promulgation of supplementary regulations such as the K-12 IRR, jointly issued by the DepEd, CHED, and TESDA, and the joint guidelines issued in coordination with DOLE. So in that case, there's no undue delegation of legislative power. Let's now move to the fundamental powers of the state, asked 11 times already. So the totality of government power is contained in three great powers. We all know this: the police power, power of eminent domain, and power of taxation. These belong to the very essence of government, and without them, no government can exist. Remember that a constitution does not grant such powers to the government because these powers are inherent to every government. The Constitution only defines and delimits them and allocates their exercise among various government agencies. So first, let's go to police power. It has been characterized as the most essential, insistent, and the least limitable of powers, extending as it does to all the great public needs. Negatively, it has been defined as that inherent and plenary power of the state that enables it to prohibit all that is hurtful to the comfort, safety, and welfare of the society. Justice Kagiwa, in our favorite case, Council of Teachers versus Secretary of Education, defined it broadly as the state's authority to enact legislation that may interfere with personal liberty or property in order to promote the general welfare. Now, what are the requisites for the valid exercise of police power? There must be lawful subject, meaning the law must have a valid governmental objective, or that the interest of the public, as distinguished from those of a particular class, requires the intervention of the state. And second, it must be through lawful means, such that the means employed must be reasonably related to the accomplishment of the purpose and not unduly oppressive. Justice Kagiwa also refers to these two requisites as the requirements of substantive due process necessary for the intrinsic validity of the law. Keep in mind that the basic limitations on the exercise of police power are, first, the due process clause, both substantive and procedural, and second, the equal protection clause. So if you're asked about the validity of a police power measure, you can assail it on three grounds: violation of substantive due process, meaning the lawful subject and lawful means analyses; violation of procedural due process, which consists, of course, of the two basic rights of notice and hearing, as well as the guarantee of being heard by an impartial and competent tribunal; and third, violation of the equal protection clause. For a violation of the equal protection clause, remember that the Constitution does not require absolute equality among persons, and all that is required is a valid, reasonable classification such that the classification is germane to the purpose of the law, not limited to existing conditions only, applied equally to all members of the same class, and rests on substantial distinction. Now let's go to the power of eminent domain, asked 7 times. The concept of eminent domain was discussed by Justice Kagiwa in PNOC versus NGCP. He said that the power of eminent domain, which is also called the power of expropriation, is the inherent right of the state to condemn private property for public use upon payment of just compensation. The right of eminent domain has been described as the highest and most exact idea of property remaining in the government that may be acquired for some public purpose through a method in nature of a compulsory sale to the state. The right of eminent domain is an ultimate right of the sovereign power to appropriate any property within its territorial sovereignty for a public purpose. The exercise of this power, whether directly by the state or by its authorized agents, is necessarily in derogation of private rights. Hence, it is considered to be one of the harshest proceedings known to the law. May the power of eminent domain be delegated? Yes. The power to expropriate is not exclusive to Congress. Congress may delegate the exercise of the power to government agencies, public officials, and quasi-public entities. According to the eminent constitutionalist and one of the framers of the 1987 Constitution, Father Joaquin Bernas, the authority of the legislature to delegate the right of eminent domain to private entities operating public utilities has never been questioned. But here comes the distinction. In the hands of government agencies, local governments, public utilities, and other persons and entities, the right to expropriate is not inherent and is only a delegated power. In fact, even as to municipal corporations, it has been held that they can exercise the right of eminent domain only if some law exists conferring the power upon them. Hence, with the right of eminent domain not being an inherent power for them, then the delegate's exercise of the right of eminent domain is restrictively limited to the confines of the delegating law. The scope of this delegated legislative power is necessarily narrower than that of the delegating authority and may only be exercised in strict compliance with the terms of the delegating law. In this PNOC case, the National Grid Corporation of the Philippines is empowered by law to expropriate private lands to build transmission lines. But PNOC is alleging that the land sought to be expropriated was a land owned by the government and hence not private land. And following the rule that the delegated power of eminent domain is restrictively limited to what the law says, then NGCP cannot expropriate public land. Justice Kagiwa, however, said that not all lands owned by the government are public lands. Some may be patrimonial property or land owned by the state in its proprietary capacity. These take the nature of private lands, like the land sought to be expropriated by the NGCP in this case. So, expropriation was allowed in this instance. Now, the usual bar question centers on the taking of property, and you are asked to determine whether the taking is compensable or not. Thus, you are called to determine if a property right is subjected to police power or eminent domain. In answering that, just remember that in the exercise of police power, a property right is impaired by regulation, or the use of property is merely prohibited, regulated, or restricted to safeguard public welfare. So the property here is noxious or dangerous. In such cases, there is no compensable taking. while in the exercise of eminent domain, a property is appropriated and applied to some public purpose, which necessitates the payment of just compensation. Now let's go to the legislative department. Apart from the plenary legislative power that it has, Congress also has a lot of non-legislative powers. This has been asked 27 times now, so let's enumerate them. Under Article 6, Section 23, Paragraph 1, the Congress, by a vote of 2/3 of both houses in joint sessions assembled, voting separately, shall have the sole power to declare the existence of a state of war. Under Article 7, Section 4, the returns of every election for President and Vice President, duly certified by the Board of Canvassers of each province of city, shall be transmitted to the Congress, directed to the President of the Senate. Upon receipt of the certificates of canvass, the President of the Senate shall not later than 30 days after the day of the election open all the certificates in the presence of the Senate and the House of Representatives in joint public session, and the Congress, upon determination of the authenticity and due execution thereof in the manner provided by law, canvass the votes. The person having the highest number of votes shall be proclaimed elected. But in case two or more shall have an equal and highest number of votes, one of them shall forthwith be chosen by the vote of a majority of all the members of both houses of the Congress voting separately. Now, under Article 7, Section 10, the Congress shall, at 10 o'clock in the morning of the third day after the vacancy in the offices of the President and Vice President, convene in accordance with its rules without need of a call, and within 7 days enact a law calling for a special election to elect a president and a vice president to be held not earlier than 45 days, nor later than 60 days from the time of such call. Then under Article 7, Section 11, whenever a majority of all the members of the Cabinet transmit to the President of the Senate and to the Speaker of the House of Representatives the written declaration that the President is unable to discharge the powers and duties of his office, the Vice President shall immediately assume the powers and duties of the office as acting President. Thereafter, when the President transmits to the President of the Senate and to the Speaker of the House of Representatives his written declaration that no inability exists, he shall reassume the powers and duties of his office. Meanwhile, should the majority of all the members of the Cabinet transmit within 5 days to the President of the Senate and to the Speaker of the House of Representatives the written declaration that the President is unable to discharge the powers and duties of his office, the Congress shall decide the issue. For that purpose, the Congress shall convene, if it's not already in session, within 48 hours in accordance with its rules and without need of call. If the Congress within 10 days after receipt of the last written declaration, or if not in session within 12 days after it is required to assemble, determines by a 2/3 vote of both houses voting separately that the President is unable to discharge the powers and duties of his office, the Vice President shall act as President. Otherwise, the President shall continue exercising the powers and duties of his office. Then we have, under Article 7, Section 18, the Congress, by voting jointly by a vote of at least a majority of all its members in regular or special session, may revoke the proclamation of martial law or suspension of the privilege of the writ of habeas corpus, which revocation shall not be set aside by the President. Upon the initiative of the President, the Congress may, in the same manner, extend such proclamation or suspension for a period to be determined by Congress, if the invasion or rebellion shall persist and public safety requires it. And then on 7, Section 19, the President shall have the power to grant amnesty with the concurrence of a majority of all the members of the Congress. Under Article 7, Section 21, no treaty or international agreement shall be valid and effective unless concurred in by at least two-thirds of all the members of the Senate. Under Article 7, Section 16, the President shall nominate and, with the consent of the Commission on Appointments, appoint the heads of the executive departments, ambassadors, and other public ministers and consuls or officers of the armed forces from the rank of colonel or naval captain, and other officers whose appointments are vested in him in the Constitution. And then, under Article 17, Section 1, the Congress, upon a vote of 3/4 of all its members, may propose amendments or revisions to the Constitution. And in Section 3 of the same article, the Congress may, by a vote of 2/3 of all its members, call a constitutional convention, or by a majority vote of all its members, submit to the electorate the question of calling such convention. And finally, the power of impeachment. Under Article 11, Section 3, the House of Representatives shall have the exclusive power to initiate all cases of impeachment, while the Senate shall have the sole power to try and decide all cases of impeachment. So please review those provisions. As I have mentioned, they have appeared 27 times in the last 15 years. Now, let's go back to the issue of non-delegability of legislative power, particularly on the exceptions thereto. Another common formulation of this question is, who may exercise legislative power? While some books and reviewers would say that what's enumerated here, are the exceptions to the non-delegability of legislative power, I disagree with the first and fourth items. Technically, as to initiative and referendum, this was not delegated to the people, but this power was actually reserved to the people, meaning it's not part of the legislative power that the people delegated to the Congress in the first place, but instead reserved it for themselves. Then, as to the delegation to administrative bodies, we have already clarified earlier that in the exercise of subordinate legislation or contingent legislation, they are not engaged in lawmaking, but rather law execution. So technically, no legislative power is delegated to them. So really, the exceptions to the non-delegability of legislative powers are only the emergency and tariff powers granted to the President and the delegation of legislative power to local government units. So technically, it's only the Congress, the President, and the LGUs that wield legislative power. Now let's jump to the military powers of the President, questions which have been asked 13 times in the last 15 years. What are the military powers of the President? The President, as the Commander-in-Chief of all armed forces of the Philippines, has the power to, first, call out the armed forces. Second, suspend the privilege of the writ of habeas corpus. And third, place the Philippines or any part thereof under martial law. These are graduated powers from the most to the least benign. It must be stressed, however, that the graduation refers only to hierarchy based on scope and effect. It does not in any manner refer to a certain sequence, arrangement, or order which the Commander-in-Chief must follow. This so-called graduation of powers does not dictate or restrict the manner by which the President decides which power to choose given a particular set of circumstances. So when may the President exercise his calling out power? Whenever it becomes necessary, the President may call out the armed forces to prevent or suppress lawless violence, invasion, or rebellion. Among the three extraordinary powers, the calling out powers is the most benign and involves ordinary police action. The power to call is fully discretionary to the President, the only limitations being that he acts within permissible constitutional boundaries, or in a manner not constituting grave abuse of discretion. In fact, according to the case of Lagman versus Medialdea, the actual use to which the president puts the armed forces is not subject to judicial review. Also, as held in IBP versus Zamora, the factual necessity of calling out the armed forces is something that is for the president to decide. Judicial inquiry can go no further than to satisfy the court. Not that the president's decision is correct, but that the president did not act arbitrarily. Thus, the standard laid down is not correctness, but arbitrariness. Now, what system of checks and balances to limit the president's exercise of martial law and the suspension powers and to establish safeguards to protect civil liberties? These were enumerated in Lagman versus Pimentel to be as follows. 1. The president may declare martial law or suspend the privilege of the writ of habeas corpus only when there is an invasion or rebellion and public safety requires such declaration or suspension. 2. The president's proclamation or suspension shall be for a period not exceeding 60 days. 3. Within 48 hours from the proclamation or suspension, the president must submit a report in person or in writing to Congress. 4. The Congress, voting jointly and by a vote of at least a majority of all its members, can revoke the proclamation or suspension. 5. The president cannot set aside the Congress's revocation of his proclamation or suspension. 6. The president cannot by himself extend his proclamation or suspension. He should ask the Congress's approval for it. 7. Upon such initiative or request from the president, the Congress, voting jointly and by a vote of at least a majority of all its members, can extend the proclamation or suspension for such period as it may determine. Number 8. The extension of the proclamation or suspension shall only be approved when the invasion or rebellion persists and public safety requires it. 9. The Supreme Court may review the sufficiency of the factual basis of the proclamation or suspension or extension thereof in an appropriate proceeding filed by any citizen. 10. The Supreme Court must promulgate its decision within 30 days from the filing of the appropriate proceeding. Eleven, martial law does not suspend the operation of the Constitution. Accordingly, the Bill of Rights remain effective under a state of martial law. Its implementers must adhere to the principle that civilian authority is supreme over the military and the armed forces is the protector of the people. They must also abide by the state's policy to value the dignity of every human person and guarantee full respect for human rights. 12. Martial law does not supplant the functioning of civil or legislative assemblies, nor authorize the conferment of jurisdiction on military courts and agencies over civilians where civil courts are able to function. 13. The suspension of the privilege of the writ applies only to persons judicially charged for rebellion or offenses inherent in or directly connected with invasion. 14. Finally, during the suspension of the privilege of the writ, any person thus arrested or detained should be judicially charged within 3 days, otherwise he should be released. I suggest that you guys memorize these 14 items as they were specifically enumerated in Lagman versus Pimentel. Now, how do we distinguish between the judicial power to review and the congressional power to revoke the proclamation of martial law and the suspension of the writ of habeas corpus? Lagman versus Medialdea cited for distinction. It said that first, The court may strike down the presidential proclamation in an appropriate proceeding filed by any citizen on the ground of lack of sufficient factual basis. On the other hand, Congress may revoke the proclamation or suspension, which revocation shall not be set aside by the President. Second, in reviewing the sufficiency of the factual basis of the proclamation or suspension, the court considers only the information and data available to the President prior to or at the time of the declaration. It is not allowed to undertake an independent investigation beyond the pleadings. On the other hand, Congress may take into consideration not only data available prior to, but likewise events supervening the declaration. Third, unlike the court, which does not look into the absolute correctness of the factual basis, Congress could probe deeper and further. It can delve into the accuracy of the facts presented before it. And fourth, the court's review power is only passive. It's such that it is only initiated by the filing of a petition in an appropriate proceeding by a citizen. On the other hand, Congress's review mechanism is automatic in the sense that it may be activated by Congress itself at any time after the proclamation or suspension was made. Lagman versus Medaldea also emphasized that the power to review by the court and the power to revoke by Congress are not totally different. I mean, they are not only totally different, but they are likewise independent from each other, although considerably they have the same trajectory, which is the nullification of the presidential proclamation. Needless to say, the power of the court to review can be exercised independently from the power of revocation of Congress. Another possible question on this topic is, what is the test for judicial review of the President's power to declare martial law and suspend the privilege of the writ of habeas corpus, and what are its parameters? Again, we rely on Lagman versus Medaldea, which clarified that the phrase sufficiency of factual basis in Section 18 of Article 7 of the Constitution should be understood as the only test for judicial review of the President's power to declare martial law and suspend the privilege of the writ of habeas corpus under Section 18, Article 7 of the Constitution. The court does not need to satisfy itself that the President's decision is correct. Rather, it only needs to determine whether the President's decision had sufficient factual basis. The parameters for determining the sufficiency of factual basis are as follows. First, actual rebellion or invasion. Second, public safety requires it. The first two requirements must concur. And third, that there is probable cause for the President to believe that there is actual rebellion or invasion. Let's now tackle judicial review, which has been asked also 13 times already. So what is judicial review? It is the power of the courts to test the validity of executive and legislative acts in light of their conformity with the Constitution. This power is not exclusive to the Supreme Court, as lower courts may also exercise this power. But it must be stressed that the exercise of judicial power is not an assertion of superiority by the courts over the other departments, but is merely an expression of the supremacy of the Constitution. So, what are the requisites of judicial review? First, there must be an actual case or controversy calling for the exercise of judicial power. An actual case or controversy is one which involves a conflict of legal rights, an assertion of opposite legal claims susceptible of judicial resolution, as distinguished from a hypothetical dispute or question, since the courts will decline to pass upon constitutional issues through advisory opinions. Related requirement of an actual case or controversy is the requirement of ripeness. And a question is ripe when the act being challenged has a direct effect on the individual challenging it. For a case to be considered ripe for adjudication, it is a prerequisite that an act had been accomplished or performed by either branch of government before a court may interfere, and the petitioner must allege the existence of an immediate or threatened injury to himself as a result of the challenged action. Next, the petitioner must have standing to question the validity of the subject act or issuance. Legal standing refers to a personal and substantial interest in a case, such that the party has sustained or will sustain direct injury as a result of the challenged governmental act. In constitutional cases, which are often brought through public actions and the relief paid for is likely to affect other persons, non-traditional plaintiffs have been given standing by the court, provided specific requirements have been met. Example, when suing as a concerned citizen, the person complaining must allege that he has been or is about to be denied some right or privilege to which he is lawfully entitled, or that he is about to be subjected to some burdens or penalties by reason of the statute or act complained of. In the case of taxpayers, they are allowed to sue where there is a claim that public funds are illegally disbursed or that public money is being deflected to any improper purpose, or that public funds are wasted through the enforcement of an invalid or unconstitutional law. On the other hand, legislators have standing to maintain and violate the prerogatives, powers, and privileges vested by the Constitution in their office. And so they're allowed to sue to question the validity of any official action which infringe upon their legislative prerogatives. Also, an organization asserting the rights of its members may also be granted standing by the court. Just like the Council of Teachers and Staff of Colleges and Universities in the Philippines in our favorite case, who represent the interests of the faculty and staff of their respective colleges and universities, and who allegedly are threatened to be demoted or removed from employment with the implementation of the K-12 law. Next requisite is that the question of constitutionality must be raised at the earliest opportunity. And finally, the constitutional question must be the very lis mota of the case, or the actual cause of action of the case, and not just an incidental issue to the case. Now let's go to political questions. The term refers to those questions which, under the Constitution, are to be decided by the people in their sovereign capacity, or in regard to which full discretionary authority has been delegated to the legislature or executive branch of the government. Before, it is very restrictive, but now, under the 1987 Constitution, the political question doctrine is no longer the insurmountable obstacle to the exercise of judicial power or the impenetrable shield that protects executive and legislative actions from judicial inquiry or review under the expanded definition of judicial power. And this expanded definition authorizes courts of justice not only to settle actual cases or controversies involving rights which are legally demandable and enforceable, but also to determine whether there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. In determining whether a grave abuse of discretion has been committed by any branch or instrumentality of the government, the court is guided primarily by the Constitution and secondarily by existing domestic and international law, which set limits or conditions to the powers and functions conferred upon these political bodies. Thus, when a case is brought before the court with serious allegations that a law or executive issuance infringes upon the Constitution, it becomes not only the right, but in fact the duty of the court to settle the dispute. But again, in doing so, the court is not judging the wisdom of an act of a co-equal department, but is merely ensuring that the Constitution is upheld. Now let's answer this possible question from our favorite case. Petitioners argue that the K-12 law only increases the resource gap by creating more need for resources. The solution to the problem, they say, is closing that resource gap by giving priority to education in the budget and public spending program of the government and addressing the issue of poverty and malnutrition and programs aimed at alleviating, if not eradicating, poverty in the long run. But instead, government comes up with the K-12 law, which is a copycat and elitist solution. Question: may the court resolve this issue? Answer: no. This is an example of a political question not covered by the expanded judicial power of the court. This is a question of policy, and Justice Kagiwa in that case said that policy matters are not the concern of the court. It is within the exclusive dominion of the political branches of the government whether an enactment is wise or unwise, whether it is based on sound economic theory, whether it is the best means to achieve the desired results, whether, in short, the legislative discretion within its prescribed limits should be exercised in a particular manner. All these are matters for the judgment of the legislature, and the serious conflict of opinions does not suffice to bring them within the range of judicial cognizance. The court, despite its vast powers, will not review the wisdom, merits, or propriety of governmental policies, but will strike them down only on either of two grounds: unconstitutionality or illegality, and grave abuse of discretion. Now, let's go to moot questions. When does a case become moot and academic? Justice Kagiwa in Pisho versus Ichret said that the case becomes moot when it ceases to present a justiciable controversy, so that a determination thereof would be without practical use and value. So, the general rule is that the courts will decline jurisdiction over such case or dismiss it on the ground of mootness. But as usual, there are exceptions. In the Philippine Association of Detective and Protective Agency Operators versus COMELEC, Justice Kagiwa said that the court has seen fit to decide cases otherwise moot if, first, there is a grave violation of the Constitution. Second, the exceptional character of the situation and the paramount public interest are involved. Third, when the constitutional issue raised requires formulation of controlling principles to guide the bench, the bar, and the public. And fourth, the case is capable of repetition yet evading review. For the fourth exception to apply, the following factors must also be present. 1, the challenge action is in its duration too short to be fully litigated prior to its cessation or expiration. And 2, there is a reasonable expectation that the same complaining party would be subjected to the same action. Now, to the operative fact doctrine. We all know that an unconstitutional law is not a law. It confers no rights, it imposes no duties, it affords no protection, it creates no office. It is inoperative, as if it has not been passed at all. The exception is the doctrine of operative fact, which applies as a matter of equity and fair play. This doctrine nullifies the effects of an unconstitutional law or an executive act by recognizing that the existence of a statute prior to a determination of unconstitutionality is an operative fact and may have consequences that cannot always be ignored. Hence, It legitimizes otherwise invalid acts done pursuant thereto because of considerations of practicality and fairness. In this regard, certain acts done pursuant to a legal provision which was just recently declared as unconstitutional cannot anymore be undone, because not only would it be highly impractical to do, but more so it would be unfair to those who have, in good faith, relied on the said legal provision prior to the time that it was struck down. It applies only to cases where extraordinary circumstances exist, and only where the extraordinary circumstances have met the stringent conditions that will permit its application. Case in point is Araulio versus Aquino, which concerns the constitutionality of the DAP, or the Disbursement Acceleration Program. The court struck it down for being unconstitutional as it involved cross-border transfers or augmentations where funds appropriated by the GAA, or the General Appropriations Act, for the executive were being transferred to the legislative and other executive agencies. Remember that while the president and even the heads of the other branches of the government are allowed by the Constitution to make realignment of funds, such transfer or realignment should only be made within their respective offices. And so, the DAP was declared unconstitutional. However, the court recognized that the DAP has definitely helped stimulate the economy, it has funded numerous projects, and if the executive is ordered to reverse all actions under the DAP, then it may cause more harm than good. The DAP effects can no longer be undone. The beneficiaries of the DAP cannot be asked to return what they receive, especially so that they have relied on the validity of the DAP. So the doctrine of operative fact was applied in this regard. But the operative fact doctrine cannot be invoked if it will constitute an unjust enrichment. Now, big jump to the requisites of a valid warrant. While this was only asked 3 times in the bar, I included it because there's a case by Justice Tegiwa on it. That is People versus Gabiosa. So, according to Section 2 of the Bill of Rights, no search warrant or warrant of arrest shall issue except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the persons or things to be seized. In People versus Gabiosa, the Court of Appeals invalidated the search warrant on the ground that the judge did not examine the complainant, but only his witness. The Court of Appeals reasoned that the text of the Constitution used the word and instead of or and or, which allegedly shows its clear intent to really require both applicant and the witness to be personally examined by the issuing judge. The Supreme Court disagreed and explained that the purpose of the examination is to satisfy the judge that probable cause exists. Hence, it is immaterial in the grander scheme of things whether the judge examined the complainant only or the witness only, and not both the complainant and the witness. The primordial consideration is that the judge is convinced that there is probable cause to disturb the particular individual's privacy. Therefore, in that case, the Court of Appeals erred in placing undue importance on the Constitution's use of the word and instead of or and or. Now, let's tackle warrantless searches. Another bar topic favorite, asked 13 times already. In People versus Sapla, Justice Kagiwa mentioned that in the Bill of Rights, the right against unreasonable searches and seizures is at the top of the hierarchy of rights, next only to, if not on the same plane as, the right to life, liberty, and property. for the right to personal security, which, along with the right to privacy, is the foundation of the right against unreasonable search and seizure. So Section 2 of the Bill of Rights provides that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature and for any purpose shall be inviolable. Hence, as a rule, a search and seizure operation conducted by the authorities is reasonable only when a court issues a warrant, because of the sacrosanct position occupied by the right against unreasonable searches and seizures in the hierarchy of rights. Any deviation or exemption from this rule is not favored and is strictly construed against the government. There are, however, instances wherein searches are reasonable even in the absence of a search warrant, taking into account the uniqueness of circumstances involving the purpose of the search or seizure, the presence and absence of probable cause, the manner in which the search and seizure was made, the place or thing searched, and the character of the articles procured. The known jurisprudential instances of reasonable warrantless searches and seizures are: 1. Consented warrantless search, when the right has been voluntarily and intelligently waived. 2. Incident to a lawful arrest, where a person caught in flagrante delicto or otherwise lawfully arrested may be searched, provided that the search is contemporaneous to the arrest and within the permissible area of search that is within the immediate control of the person being arrested. It is essential that a valid arrest must precede the search and not the other way around. Take note that it is also applicable to citizens' arrests. 3. Search of moving vehicles. According to People versus Sapla, warrantless search and seizure of moving vehicles are allowed in recognition of the impracticability of securing a warrant, as the vehicle can be quickly moved out of the locality or jurisdiction in which the warrant may be sought. These officers in such cases, however, are limited to routine checks where the examination of the vehicle is limited to visual inspection. On the other hand, an extensive search of a vehicle is permissible, but only when the officers made it upon probable cause, or upon a belief reasonably arising out of circumstances known to the seizing officer that an automobile or other vehicle contains an item, article, or object which by law is subject to seizure and destruction. However, sheer unverified information from an anonymous informant does not engender probable cause on the part of the authorities that would warrant an extensive and intrusive search of a moving vehicle. The court, in the case of People versus Sapla, held with unequivocal clarity that in situations involving warrantless searches and seizures, law enforcers cannot solely act on the basis of confidential or tipped information. A tip is still hearsay, no matter how reliable it may be. It is not sufficient to constitute probable cause in the absence of any other circumstance that will arouse suspicion. 4. Customs search. This is when persons exercising police authority under the customs law effect search and seizure in the enforcement of customs law. However, customs searches are not available in dwelling places. 5. Body checks in airports. According to RA 6235, or the Act Prohibiting Certain Acts to Civil Aviations, every ticket issued to a passenger by the airline or air carrier shall contain the following condition printed thereon. Holder hereof and his hand-carried luggage are subject to search for and seizure of prohibited materials or substances. holder refusing to be searched shall not be allowed to board the aircraft, which shall constitute a part of the contract between the passenger and the air carrier. Number 6, inspection of buildings and other premises for the enforcement of fire, sanitary, and building regulations. 7, when there is a genuine reason to stop and frisk in light of a police officer's experience and suspicious circumstances to warrant the belief that the person stopped has concealed weapons or contraband. 8, checkpoints. To be valid, it must only be limited to a visual search, meaning passengers must not be subjected to body search, and the vehicle should also not be searched. 9, we have the plain view doctrine. To be valid, it requires that the law enforcement officer has a prior valid justification for the initial intrusion and be legally present there in the pursuit of their official functions. It's also required that evidence was inadvertently discovered by the police who have the right to be where they are, and that it must be immediately apparent to the police that the items they observe may be evidence of a crime, contraband, or otherwise subject to seizure. Number 10, finally, we have exigent circumstances, where under such urgency and exigency of the moment, there is no more time to secure a search warrant. Now let's go to freedom of religion. This topic had been asked for a whopping 16 times in the last 15 years. Section 5 of the Bill of Rights provide that no law shall be made respecting an establishment of religion or prohibiting the free exercise thereof. The free exercise and enjoyment of religious profession and worship without discrimination or preference shall forever be allowed. No religious test shall be required for the exercise of civil or political rights. From this, we can see that the constitutional assurance of religious freedom provides two guarantees: the non-establishment clause and the free exercise clause. Now, what is the non-establishment clause? The non-establishment clause principally prohibits the state from sponsoring any religion or favoring any religion as against other religions. It mandates a strict neutrality in affairs among religious groups. Essentially, it prohibits the establishment of a state religion and the use of public resources for the support or prohibition of a religion. But there are constitutionally created exceptions to this. First, we have certain tax exemptions. Charitable institutions, churches, and parsonages or convents appurtenant thereto, mosques, non-profit cemeteries, and all lands, buildings, and improvements actually directly and exclusively used for religious, charitable, or educational purpose shall be exempt from taxation. Second, we have the limited public aid to chaplaincies, which provides that no public money or property shall be appropriated, applied, paid, or employed directly or indirectly for the use, benefit, or support of any sect, church, denomination, sectarian institution, or system of religion, or of any priest, preacher, minister, or other religious teacher or dignitary as such, except when such priest, preacher, minister, or dignitary is assigned to the armed forces or to any penal institution or government orphanage or leprosarium. Next, we have the allowance of religious instruction in public elementary and high schools, where at the option expressed in writing by the parents or guardians, religion shall be allowed to be taught to their children or wards in public elementary and high schools within the regular class hours by instructors designated or approved by the religious authorities of the religion to which the children or wards belong, without additional cost to the government. And finally, the nationality exemption to ownership of educational institutions by religious groups, which states that educational institutions other than those established by religious groups and mission boards shall be owned solely by citizens of the Philippines or corporations or associations, at least 60% of the capital of which is owned by such citizens. Now, what is the Free Exercise Clause? The right to religious profession and worship has twofold aspects: freedom to believe and freedom to act on one's belief. The first is absolute, as long as the belief is confined within the realm of thought. The second is subject to regulation, where the belief is translated into external acts that affect the public welfare. According to Justice Caguioa in Valmores versus Achacoso, in a nutshell, the Constitution guarantees the freedom to believe absolutely, while the freedom to act based on belief is subject to regulation by the state when necessary to protect the rights of others and in the interest of public welfare. So, in that case, Valmores was a medical student at Mindanao State University. He asked to be excused from classes and other academic activities on account of his religious beliefs as a member of the Seventh-day Adventist Church, whose fundamental beliefs include the strict observance of the Sabbath as a sacred day. The court held that it fails to see how public order and safety will be served by the denial of Valmores' request for exemption. Neither can the court see how Valmores' absence from Saturday classes would be injurious to the rights of others. So the court in that case upheld Valmores' right to his free exercise of religion. Next concept under religious freedom is the benevolent neutrality or accommodation. According to Estrada versus Escritor, the intent of the framers of our Constitution was to adopt a benevolent neutrality approach in interpreting the religious clauses in our Constitution. The benevolent neutrality theory believes that with respect to governmental actions that have a secular purpose and general applicability, but may incidentally or inadvertently aid or burden religious exercise, accommodation of religion may be allowed, not to promote the government's favored form of religion, but to allow individuals and groups to exercise their religion without hindrance. The purpose of accommodation is to remove a burden on or facilitate the exercise of a person's or institution's religion. Thus, what is sought under the theory of accommodation is not a declaration of unconstitutionality of a facially neutral law, but an exemption from its application or its burdensome effect. Now, who are conscientious objectors? Originally, the term conscientious objector refers to a person who, for moral or religious reasons, is opposed to participating in any war, and who may be excused from military conscription but remains subject to service in civil work for the nation's health, safety, or interest. But in Imbong versus Ochoa, it was used to refer to medical practitioners who, for religious reasons, are opposed to the RH law and are thus made exempt from its mandates. The court reasoned that if the conscientious objector would be compelled to act contrary to his or her religious belief and conviction, it would be violative of the principle of non-coercion enshrined in the constitutional right to free exercise of religion. Now, what are the tests to determine the validity of government regulation in the area of religious freedom? First, we have the Lemon Test. It is a test to determine whether an act of the government violates the non-establishment clause. To pass the Lemon Test, a government act or policy must 1. Have a secular purpose. 2. not promote or favor any set of religious beliefs or religion generally. And 3, not get the government too closely involved or entangled with religion. Then we have the compelling state interest test. This is used to determine if the interests of the state are compelling enough to justify infringement of religious freedom. It involves satisfying these 3 questions. A. Has the statute of government action created a burden on the free exercise of religion? B. Is there a sufficiently compelling state interest to justify this infringement of religious liberty? And C. Has the state, in achieving its legitimate purposes, used the least intrusive means possible so that the free exercise is not infringed any more than necessary to achieve the legitimate goal of the state? Now let's tackle another bar favorite topic, the freedom of speech and expression. Section 4 of the Bill of Rights states that no law shall be passed abridging the freedom of speech, of expression, or of the press, or of the right of the people peaceably to assemble and petition the government for redress of grievances. According to Father Bernas, the doctrine on freedom of speech was formulated primarily for the protection of core speech, such as speech which communicates political, social, or religious ideas. Those enjoy the same degree of protection. It also includes every form of expression, whether oral, written, tape, or recorded. It also includes movies, symbolic speech, such as wearing of pins and armbands, peaceful picketing, and conduct which amounts to speech. The 2 aspects of freedom of expression are freedom from prior restraint and freedom from subsequent punishment. What is prior restraint? It refers to official governmental restrictions on the press or other forms of expression in advance of actual publication or dissemination. Freedom from prior restraint is largely freedom from government censorship of publications, whatever the form of censorship, and regardless of whether it is wielded by the executive, legislative, or judicial branch of the government. But, as usual, there are exceptions. So, what are the examples of valid prior restraint? 1. Movies, televisions, and radio broadcast censorship in view of its access to numerous and broad audience, including the young, who must be insulated from the prejudicial effects of unprotected speech. Then we have prior restraint of unprotected speech, such as pornography, false or misleading commercial advertisements, advocacy of imminent lawless action, which can be a danger to national security, and laws against defamation and libel. We also have the sub judice rule, which restricts comments and disclosures pertaining to judicial proceedings to avoid prejudging the issue, influencing the court, or obstructing the proper administration of justice. What is the concept of freedom from subsequent punishment? The aspect of freedom from liability subsequent to publication precludes liability for completed publications of views traditionally held innocent. Without this, the prohibition on prior restraint would be meaningless, as the unrestrained threat of subsequent punishment by itself would be an effective prior restraint. Thus, opinions on public issues cannot be punished when published merely because the opinions are novel or controversial, or because they clash with current doctrines. This fact, however, does not imply that publishers and editors are never liable for what they print. Such freedom gives no immunity from laws punishing scandalous or obscene matter, seditious or disloyal writings, and libelous or insulting words. The first step in determining the validity of a government regulation on free expression is to classify whether the regulation is content-based or content-neutral. Content-based restriction is based on the subject matter of the utterance or speech and thus treated as more suspect than content-neutral laws. Content-neutral regulation is merely concerned with the incidents of the speech, or one that merely controls the time, place, or manner, and under well-defined standard. Content-neutral regulations of speech or of conduct that may amount to speech are subject to lesser but still heightened scrutiny. So, which test is applied when the prior restraint is in the form of a content-based regulation? According to Chavez versus Gonzalez, the clear and present danger rule is applied to content-based regulation. A government action that restricts freedom of speech or of the press based on contents is given the strictest scrutiny in light of its inherent and invasive impact. Only when the challenged act has overcome the clear and present danger rule will it pass constitutional muster, with the government having the burden of overcoming the presumed unconstitutionality. It will pass constitutional muster only if justified by a compelling reason and the restrictions are neither overbroad nor vague. Now, which test is applied when the prior restraint is in the form of a content-neutral regulation? The intermediate approach is applied, since regulations of this type are not designed to suppress any particular message. They are not subject to the strictest form of judicial scrutiny, but only an intermediate approach that is somewhere between mere rationality that is required of any other law and the compelling interest standard applied to content-based restrictions. The intermediate approach has been formulated in this manner. A governmental regulation is satisfied if 1. It is within the constitutional power of the government, 2. If it furthers an important or substantial government interest, 3. If the government interest is unrelated to the suppression of free expression, and 4. If the incident restriction on alleged freedom of speech and expression is no greater than what is essential to the furtherance of that interest. The next concept that we need to know by heart is facial challenge. The facial challenge principle is a challenge against the constitutionality of a statute that can be filed even where the petitioner claims no actual violation of his own rights under the assailed statute, but relies on the potential violation of his or other person's rights. A facial challenge is allowed to be made to a vague statute and to one which is overbroad because of possible chilling effect upon protected speech. The possible harm to society in permitting some unprotected speech to go unpunished is outweighed by the possibility that the protected speech of others may be deterred and perceived grievances less to fester because of possible inhibitory effects of overly broad statutes. The facial challenge is a prerequisite to assailing a statute or a government action on the ground of overbreadth. The overbreadth doctrine is a ground to declare a statute void when it offends the constitutional principle that a government purpose to control or prevent activities constitutionally subject to state regulations may not be achieved by means which sweep unnecessarily broadly and thereby invade the area of protected freedoms. The application of the overbreadth doctrine is limited to a facial kind of challenge, and owing to the given rationale of a facial challenge, applicable only to free speech cases. In overbreadth analysis, Challenges are permitted to raise the rights of third parties, and the court invalidates the entire statute on its face, not merely as applied for, so that the overbroad law becomes unenforceable until a properly authorized court construes it more narrowly. The factor that determines courts to depart from the normal adjudicatory rules is the concern with the chilling deterrent effect of the overbroad statute on third parties not courageous enough to bring suit. The court assumes that an overbroad law's very existence may cause others, not before the court, to refrain from constitutionally protected speech or expression. An overbreadth ruling is designed to remove the deterrent effect on the speech of those third parties. Now let's look at this question. It has been held that a facial challenge grounded on overbreadth or the void for vagueness doctrine is not applicable to penal statutes. But what if the penal statute encroaches on free speech? Then the answer is yes. When a penal statute encroaches upon the freedom of speech, a facial challenge grounded on the void for vagueness doctrine is acceptable. The inapplicability of the doctrine must be carefully delineated. As Justice Carpio explained in his dissent in Romualdez versus Comelec, we must view these statements of the court on the inapplicability of the overbreadth doctrine and vagueness doctrines to penal statutes as appropriate only insofar as these doctrines are used to mount facial challenges to penal statutes not involving free speech. Now let's do a big jump to candidacy because questions on this topic have been asked 14 times already. So who is a candidate? A candidate refers to any person aspiring for or seeking an elective public office who has filed a certificate of candidacy or COC by himself or through an accredited political party, a groupment, or coalition of parties. Any person may thus file a COC on any day within the prescribed period for filing a COC. Yet that person shall be considered a candidate for purposes of determining his possible violation of election laws only during the campaign period. What is a certificate of candidacy? It is a statement of a person seeking to run for a public office certifying that he announces his candidacy for the office, the name of the political party to which he belongs, if he belongs to any, and his post-office address for all election purposes being stated. A COC is a candidate's best evidence of statutory eligibility to be elective for an elective post. It is the document which formally accords upon a person the status of a candidate. This is a frequent question that we often see in the bar exams. Distinguish the effect of the filing of candidacy between an appointed official and an elected official. On appointed officials, any person holding a public appointive office or position, including active members of the armed forces and officers and employees in government-owned or controlled corporations, are considered ipso facto resigned from his or her office and must vacate the same at the start of the day of the filing of his or her certificate of candidacy. Said appointed officials would have unfair advantage over their rivals because they might use their office resources for their campaigns. On elected officials, they are allowed to continue to hold office whether they run for the same or different positions. Next, let's look into the rules on substitution and withdrawal. So 1, an official candidate of a duly registered political party or coalition who dies, withdraws, or is disqualified for any cause after the last date for the filing of COCs may be substituted by a candidate belonging to and nominated by the same political party or coalition. It is important to remember here that there are two kinds of substitution, voluntary and involuntary. Voluntary for those who withdrew and involuntary for those who died or are disqualified. Number two, no substitute shall be allowed for any independent candidate. The reason is simple, since the substitute is supposed to belong to and be nominated by the same political party or coalition. Third, the substitute for a candidate who died or is disqualified by final judgment may file a COC up to midday of election day, provided that the substitute and the one being substituted have the same surnames. But this is only for involuntary substitution. If not the same surname but belonging to the same party, the COMELEC would usually issue a resolution for the deadline of substitution. Number four, a candidate who is disqualified under Section 68 or election offenses of the Omnibus Election Code can be validly substituted because he remains a candidate until disqualified. But a person whose certificate of candidacy has been denied due course and or cancelled under Section 78 on the ground of material misrepresentation cannot be substituted because he is not considered a candidate in the first place. Number five, any candidate may withdraw his candidacy anytime before election day, but no person who has withdrawn his candidacy for a position shall be eligible as a substitute candidate for any other position.
Stressed out? Wishing for new ways to learn and master codal provisions? Codify makes it easy. With just a few taps, you can customize and select the tracks to memorize or study further. With Codify's Playlist Manager, choose from the subjects and create your own playlist. Imagine your own law track. Experience studying the law anytime, anywhere. Fortify learning with Codify. Meet your new learning buddy. Download Codify now. Achieve your learning goals, one track at a time. Listen and learn with Codify. Get the app today. Your first 7 days are on us.
Okay, now who are nuisance candidates? Nuisance candidates are those whose COCs are filed to put the election process in mockery or disrepute, or to cause confusion among the voters by the similarity of names of the registered candidates, or by other circumstances or acts which clearly demonstrate that the candidate has no bona fide intention to run for the office for which the COC has been filed, and thus prevent a faithful determination of the true will of the electorate. However, the COMELEC cannot motu proprio deny due course to or cancel an alleged nuisance candidate's certificate of candidacy without providing the candidate his opportunity to be heard. The votes cast for a nuisance candidate declared as such in a final judgment shall be considered as stray votes. However, were such candidate so declared as nuisance prior to election day, and he or she has the same surname as that of a legitimate candidate, votes cast for the nuisance candidates are not stray, but must be counted in favor of the legitimate candidate. Some factors to consider in determining whether a candidate is nuisance or not include 1. Capability to wage nationwide campaign. 2. Running under a slate. 3. Organization and machinery. 4. Performance in previous elections. 5. Platform of government. 6. Political party affiliation and support. 7. Popularity. 8. Properties. 9. Political exposure. 10. Intention to run for office. 11. Profession. 12. Educational attainment. 13. Similarity in name with other candidates. 14. Income. And finally, qualifications and disqualifications. Now let's go to remedies in election law. This particular topic has been asked for 12 times now in the bar exams. In Marcos versus Robredo, the Supreme Court explained that the results of an election may be challenged through different legal vehicles. First, failure of election cases. Second, pre-proclamation petitions. And third, election contests. These have substantive and procedural differences with varying remedies. But what remains consistent among all modalities is the requirement of specificity, particularity on one's allegations, grounds, and basis, cuts across all mechanisms for challenging election outcomes and must be present in all actions, regardless of the mode. Under BP 881 or the Omnibus Election Code, a failure of election may be declared if, on account of force majeure, violence, terrorism, fraud, or other analogous causes, the election in any polling place has not been held on the date fixed or had been suspended before the hour fixed by law for the closing of the voting, or such election results in a failure to elect, or in any of such cases, the failure or suspension of election would affect the result of the election. For its declaration, the alleged illegality must have affected more than 50% of the votes cast. Now, for a pre-proclamation controversy, concerns questions only affecting the proceedings of the Board of Canvassers or any matter raised under sections 233, 234, 235, and 236 of the Omnibus Election Code in relation to the preparation, transmission, receipt, custody, and appreciation of the election returns. Further, only the issues provided in Section 243 of the Omnibus Election Code may be raised in a pre-proclamation controversy. The restrictive and exclusive list includes A. The illegal composition or proceedings of the Board of Canvassers. B. The canvass election returns are incomplete, contain material defects, appear to be tampered with or falsified, or contain discrepancies in the same returns or in the authentic copies thereof. C. The election returns were prepared under duress, threats, coercion, or intimidation, or they are obviously manufactured or not authentic. And D. When substitute or fraudulent returns in controverted polling places were canvassed, the results of which materially affected the standing of the aggrieved candidate or candidates. But under the automated election system, pre-proclamation controversies now only cover two issues, both concerning the Board of Canvassers. First, its illegal composition, and second, its illegal proceedings. Finally, let's talk about election contests, which only contemplate post-election scenarios. They take the form of either an election protest or a petition for quo-warranto. Although distinct, both actions aim to unseat a winning candidate after proclamation and assumption of office. An election protest involves a contest between the defeated and winning candidates on the grounds of fraud or irregularities in the casting and counting of ballots, or in the preparation of the returns. It is centered on the issue of who actually and validly obtained the plurality of votes. A petition for quo warranto, on the other hand, is defined as an action against a person who usurps, intrudes into, or unlawfully holds or exercises a public office. It is appropriate only for the purpose of questioning the election of a candidate on the ground of disloyalty or ineligibility. The Constitution established distinct electoral tribunals to serve as the sole judges of all contests relating to the elections, returns, and qualifications concerning national elective positions. The Senate Electoral Tribunal rules on senatorial contests, the House of Representatives Electoral Tribunal on representatives, and the Supreme Court as the Presidential Electoral Tribunal on the President and the Vice President. Now let's jump to the nature of the corporate powers of LGUs. Please remember that municipal corporations in the Philippines are mere creatures of Congress. As such, said corporations have only such powers as the legislative department may have deemed fit to grant them. By reason of the limited powers of local governments and the nature thereof, these powers are to be construed strictly, and any doubt or ambiguity arising out of the terms used in granting said powers must be resolved against the municipality. Questions on this principle have been asked 12 times in the bar. And if you'd like to read, your bar chair has a case on this. It's entitled City of Batangas versus Philippine Shell Petroleum Corporation and Shell Philippines Exploration BV. Now, another big jump to the concept of diplomatic immunity. Another bar favorite, also appearing 12 times in the last 5 years. The usual factual scenario on this necessitates that we, or the bar examinee, distinguish between a diplomat and a consul. So, diplomats are concerned with the political relations of states, while consuls are not, but rather they attend to administrative and economic issues. Diplomats are covered by the Vienna Convention on Diplomatic Relations, while consuls are covered by the Vienna Convention on Consular Relations. So let's distinguish between diplomatic immunity and consular immunity. Diplomatic immunity is a principle of international law by which certain foreign government officials are not subject to the jurisdiction of local courts and other authorities for both their official and, to a large extent, their personal activities. Its purpose is not to benefit individuals, but to ensure the efficient performance of the functions of diplomatic missions as representing states. While consular immunity is a lesser form of diplomatic immunity, consular officers and consular employers merely have functional immunity or immunity from the jurisdiction of the receiving state in respect of acts performed in the exercise of consular function, but they do not enjoy the broader personal immunity accorded to diplomats. However, some authors still call consular immunity as diplomatic immunity or as a form thereof. So what are some of the immunities and privileges of a diplomatic mission? First, we have personal inviolability. So diplomatic agents, these are the heads of the mission or even members of the diplomatic staff, They are not liable for any form of arrest or imprisonment. 2. Diplomatic agents are immune from criminal, civil, or administrative liability, except in the case of A real action relating to private immovable property situated in the territory of the receiving state, unless he holds it on behalf of the sending state for the purposes of the mission. B. An action relating to succession in which the diplomatic agent is involved as executor, administrator, heir, or legatee as a private person, and not on behalf of the sending state. C. An action relating to any professional or commercial activity exercised by the diplomatic agent in the receiving state outside his official functions. 3. Inviolability of premises. Premises of the mission, furnishings, and means of transport shall be immune from search, seizure, and attachment or execution. 4. Archives or documents shall be inviolable. 5. The receiving state shall protect the official communication and official correspondence of diplomatic missions. 6. The receiving state shall ensure all members of diplomatic mission freedom of movement and travel. 7. A diplomatic agent is exempted to give evidence as a witness. 8. Exemption from general duties and taxes, including custom duties with certain exceptions. 9. The diplomatic bag of diplomatic agents shall not be opened or detained. And 10. The private residence of a diplomatic agent shall enjoy the same inviolability and protection as the premises of the mission. Now, let's contrast this with the immunities and privileges of a consular officer. 1. A consular officer only have immunity from jurisdiction for acts performed in their official capacity. 2. For acts done not in their official capacity, consular officers may not be arrested or detained pending trial, except in the case of a grave crime and pursuant to a decision by the competent judicial authority in the receiving state. 3. They also enjoy inviolability of their correspondence, archives, and other documents. 4. Freedom of movement and travel. 5. Members of a consular post are under no obligation to give evidence on the following situations. A. Concerning matters connected with the exercise of their functions. B. To produce official correspondence and documents. And C. To give evidence as expert witness with regard to the law of the sending state. And finally, in stark contrast to the premises of a diplomatic mission, only that part of the consular premises which is used exclusively for the purpose of the work of the consular post are inviolable. We also need to talk about the immunities of international organizations and its officers. It has been held that one of the basic immunities of an international organization is immunity from local jurisdiction. In other words, it is immune from the legal writs and processes issued by the tribunals of the country where it is found. The obvious reason for this is that the subjection of such an organization to the authority of the local courts would afford a convenient medium through which the host government may interfere in their operations or even influence or control the policies and decisions of the organization. Besides, such subjection to local jurisdiction would impair the capacity of such body to discharge its responsibilities impartially on behalf of its member states. And now for our last topic, let's look into the basic principles of international humanitarian law. Questions on these have appeared 11 times in the last 15 years. So, what is IHL? IHL is a set of rules that seek to limit the humanitarian consequences of armed conflicts. It is sometimes also referred to as the law of armed conflict or the law of war, jus in bello. The primary purpose of IHL is to restrict the means and methods of warfare that parties to a conflict may employ, and to ensure the protection and humane treatment of persons who are not or no longer taking a direct part in the hostilities. In short, IHL comprises those rules of international law which establish minimum standards of humanity that must be respected in any situation of armed conflict. What then is an armed conflict? An armed conflict exists whenever there is a resort to armed force between states or a protracted armed violence between governmental authorities and organized armed groups or between such groups within a state. The armed confrontation must reach a minimum level of intensity, and the parties involved in the conflict must also show a minimum level of organization. It does not include internal disturbances such as riots, sporadic acts of violence, and other acts of similar nature. Now, what are the core principles of IHL? First, we have the principle of humanity. This principle forbids the infliction of all suffering, injury, or destruction not necessary for achieving the legitimate purpose of a conflict. Next, let's talk about the principle of proportionality, which prohibits attacks against military objectives which are expected to cause incidental loss of civilian life, injury to civilians, damage to civilian objects, or a combination thereof, which would be excessive in relation to the concrete and direct military advantage anticipated. In other words, the principle of proportionality seeks to limit damage caused by military operations by requiring that the effects of the means and method of warfare used must not be disproportionate to the military advantage sought. Next, we have the principle of military necessity. This permits only that degree and kind of force required to achieve the legitimate purpose of a conflict. For example, the complete or partial submission of the enemy at the earliest possible moment with the minimum expenditure of life and resources. It does not, however, permit the taking of measures that would otherwise be prohibited under international humanitarian law. Fourth, we have the principle of distinction. It provides that parties to an armed conflict must, at all times, distinguish between the civilian population and combatants, and between civilian objects and military objectives, and accordingly shall only direct their operations against military objectives. This implies that indiscriminate attacks and the use of indiscriminate means and methods of warfare are prohibited. And finally, we have the principle of precaution. It states that a party to an armed conflict must take reasonable care to spare civilians and civilian objects when carrying out their military operations. The party conducting an attack must do everything feasible to verify that the target are actually military objectives and not civilian objects. What or who are prisoners of war? Prisoners of war refer to lawful combatants who have fallen into the power of the enemy. As such, POWs, they have the following rights: to be treated humanely, not to be subject to torture, to be allowed to communicate with their families, to receive food, clothing, religious articles, and medicine, to be aware of the bare minimum of information, to keep personal belongings, to proper burial, to be grouped together according to their nationality, to the establishment of an informed bureau, and to repatriation for the sick and the wounded. And finally, we look into the rule on neutrality. In a conflict, there are some who, of course, wish to stay out of the way and adopt an attitude of impartiality. Such an attitude must be recognized by the opposing parties, and they should create both rights and duties in the neutral states. The decision to employ a neutral stance is dictated by political and internal mechanisms. Neutral states must not engage in activities which interfere with the activities of the belligerents, while the latter must also respect the former's rights. Thus, a neutral state may not: 1. Openly participate in hostilities. 2. Lend assistance to belligerents. 3. Recruit troops for the belligerents or allow third parties to do so on its territory. 4. Supply military equipment on any pretext whatsoever. And last, supply military intelligence. Apart from these prohibitions, a neutral state retains the right to trade with all belligerent states. All right, and that's a wrap. That's all that I have for you today. I hope that this short lecture had been helpful. Please know that I'm fervently praying for all of you. So, again, this is Nina Rantes of the Ateneo de Naga College of Law, saying, keep calm, love and lungs. See you all at the oath taking. God bless.
Thank you to Nina for sharing with us her extensive knowledge on political law. And thank you to our partners Rex Bookstore and Rex Educampion for making this event possible. We would like to remind everybody that our frequently asked topics on the Bar Subjects lecture series will continue tomorrow, November 7th. So make sure to follow the PALS Facebook page and Rex Bookstore's Facebook page for the roster speakers and for further updates. We hope that everybody tuned in to our stream learned a lot from today's lecture. And thank you, everybody. Have a great afternoon, and we'll see you all tomorrow.